Hi everyone, this is David O'Dea with O'Dea Schneider PLLC. Today I'm breaking down the difference between Miranda rights, which apply in the civilian justice system, and Article 31 rights, which apply in the military justice system under the Uniform Code of Military Justice, or UCMJ. Both rights protect individuals against self-incrimination, but they operate differently in terms of who they apply to, when they apply, and what's required. Now, let's first start with Miranda rights. These come from the 1966 Supreme Court case Miranda versus Arizona. The court ruled that individuals must be informed of certain constitutional rights before being interrogated by law enforcement, specifically the Fifth Amendment right against self incrimination and the Sixth Amendment right to counsel, where the right to counsel under Miranda generally applies once a suspect is in custody and subject to questioning and formal legal proceedings are underway. You've probably heard the basic warning before. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, etc., etc. But here's the key. Miranda only applies when two conditions are met. First, the person must be in custody, meaning they are not free to leave. Second, they must be subject to interrogation, meaning police are asking questions likely to elicit an incriminating response. If both conditions are met and the police fail to give Miranda warnings, then any statement made may be excluded from evidence in court. But if a person isn't in custody or voluntarily makes a statement without being questioned, Miranda does not apply. Now let's look at the military side where the protections are broader. Under Article 31B of the Uniform Code of Military Justice, service members must be informed of their rights as soon as they are suspected of an offense and before any questioning occurs by someone acting in an official capacity. This could include law enforcement officers, commanders, or even fellow service members operating in an official role. The warning must include the nature of the suspected offense, the right to remain silent, and that any statement made may be used as evidence against them. Unlike Miranda, Article 31 does not require the service member to be in custody. The protections kick in earlier because military structures carry unique level of command authority, an implied pressure that could influence a service member to speak involuntarily. To compare directly, Miranda rights are reactive. They apply only when a civilian is in custody and under interrogation. Article 31 rights are proactive. They must be given as soon as a military member is suspected of a crime and questioned by anyone acting in an official capacity, whether or not they're in custody. Also, it doesn't matter whether the person doing the questioning is law enforcement or a superior within the military chain of command. Article 31 still applies. To sum up, Miranda protects civilians in specific scenarios involving custodial interrogation. Article 31 protects military personnel more broadly and sooner. Both systems, military or civilian, uphold the Fifth Amendment, but the military's approach is stronger, earlier, and provides more protection in the system based on the unique structure and the dynamics of military life. Thanks for watching, and as always, reach out to a qualified attorney if you have any sort of questions. All facts and circumstances in every case leads to very different results.